Court judge dismisses some, but not all charges in Nebraska medical cannabis lawsuit, you guys. That's right. A Lancaster County District Court judge on Friday allowed the lawsuit against the state's active medical cannabis petitions to move forward. Judge Susan Strong is in a 14-page ruling determined that the lawsuit from John Kuhn, a veterinarian rancher from former state senator and former member of the Nebraska State Board of Health, should proceed on 2 counts that relate to voter signatures. The judge dismissed the other complaints on the ballot sponsor statement and the Nebraska Constitution's single subject rule. Well, that's good news. And for the lawsuit to move forward, Kuhn needs to allege, in quote, sufficient facts for relief that is plausible on its face, which Strong said she balanced with the public's right to petition. In a quote, "We have repeatedly said that the right to initiative is precious to the people and one which the courts are zealous to preserve to the fullest tenable measure of spirits as well as the letter." The Nebraska Supreme Court ruled in a related lawsuit 2 weeks ago, which Strong cited on Friday, and there are 2 petitions in circulation that would adopt the following state laws if given voter approval. Nebraska Medical Cannabis Regulation Act define cannabis and legalize possessing, manufacturing, distributing, delivering, and dispensing cannabis for medical purposes, and create the Nebraska Medical Cannabis Commission to oversee the new state law, Initiative Measure 437. And Nebraska Medical Cannabis Patient Protection Act set an allowable amount of medical cannabis at 5 ounces and exempt patients and caregivers from using or assisting someone else in using the cannabis, and require a written recommendation from a healthcare practitioner prior to a prescription, even though, Nick Bradley, we all know it's a recommendation because they already used that the first time, okay? But nonetheless, Kuhn has alleged there are more than enough improperly counted valid signatures that the 2 medical cannabis petitions should be withheld from the November 5th ballot. If that is impossible, but there are still enough valid signatures, Kuhn argued that those election results should be void. The campaign needs 86,499 valid signatures on each of its 2 petitions to regulate and legalize the drug, and Secretary of State Bob Envin, who is also named in the lawsuit, validated nearly 90,000 signatures on both petitions, September 13th, the final day to do so. And we covered that on High at 9 News as well. That leaves just about 3,000 signatures in wiggle room for the bulk signature requirement, and Kuhn has alleged that at least one petition upward of at least 17,000 signatures were validated but should have been discarded. Those allegations range from signers not being registered voters or Envin counting duplicative signatures to improper notarizations and circulator payments, disclosures, or incomplete voter information like the date of birth and home address, he's citing. Strong also cites Kuhn's allegations that at least 2,433 signers were not registered voters and that 48 signers did not register to vote until after the petition was due July 3rd, that 67 people signed more than once but were counted both times, and the ballot sponsors didn't dispute that if some of the laundry list of reasons are accurate. Some signatures should not have been counted, and Strong wrote, but the sponsors also say the main requirement that the signer be registered to vote wouldn't be enough to invalidate the petitions. Defining a clerical or technical error, Strong said state law does allow some clerical and technical errors to be disregarded if certain other signature gathering requirements are substantially followed. But defining what is a technical error will likely be the next step. As Strong said, it is purely a question of law. In a quote, the court agrees with the sponsors that not every error or irregularity should invalidate a signature, Strong wrote. As an example, she said, whether it is a technical error that some signatures didn't include a date when the voter signed but are sandwiched between 2 other signatures with the same date, obviously the language of the Nebraska Constitution and statutes is also relevant to whether a defect or technical or clerical, Strong wrote. But the court declines to resolve this issue as the pleadings stage based only on the court's opinion of the relative importance of the statutory requirements alleged violated. Strong allowed the case to move forward to determine whether there are enough signatures in a broader review, and Krista Eggers, campaign manager for the ballot measure, said in a statement, the group is grateful for Strong's decision to dismiss 2 complaints and will continue to exercise all legal options against the signature-based challenges. In an additional quote, we have complete confidence that our local election officials correctly and accurately validated the petition signatures and that our campaign met all legal requirements to appear on the ballot, Eggers said. We remain focused on making sure all Nebraskans have their voice heard on this issue. Kuhn's attorneys had no immediate comment, and in a separate complaint from the Secretary of State, Evan and the Nebraska Attorney General Mike Hilger specifically asked the court in a separate cross-claim to take up the case, particularly after uncovering at least one instance of alleged petition fraud by a paid petition circulator in Grand Island, who was arrested for allegedly forging signatures, and those signatures were never counted. Election officials have confirmed that, and the two Constitution officers have said the case will help election integrity and the bedrock of democratic governance and settle the matter. Strong said Evanham has not requested any relief that would be indifferent that of Kuhn, and said it's unclear whether Evanham has a personal stake in the outcome or a legal or equitable right, title, or interest in the subject of controversy. The judge also pointed to a recent Supreme Court concurrence from Chief Justice Mike Havikian and Justice Lindsay Miller Lerman that there is, in quotes, no process by which the secretary can change his mind and rescind his legal sufficiency determination. And that's in the ballot sponsor complaint. And there's 2 other allegations that Strong dismissed were that one of the sponsors, State Senator Anna Wishart of Lincoln, did not provide her full street address when she filled out the petition, and that the regulatory petition consists of multiple subjects in violation of the Nebraska Constitution. In Wishart's case, she listed her street address but not her city, state, or zip code, and which Kuhn said should invalidate both petitions, and Strong said no other Nebraska case law has defined street address as it relates to the petition's laws. Citing dictionary.com, she said Wishart would still comply as she listed the name or number of a building along with the name of the road or street on which it is located. However, even if accepting Kuhn's allegations, Strong wrote, Wishart would still prevail as she is on record in taking responsibility for the petition, and her statement was also notarized in Lancaster County where she lives, Strong said. Single subject requirements. On the other side, the Nebraska Constitution prohibits state laws and ballot measures from containing more than one subject, just like in Florida, in an effort to prevent log rolling or the swaying of interests. And there's a little bit more of the story, but you can check it out on our website. We're already over time. I can't wait to hear what you guys have to say about this.
Well. I mean,
looks like Nebraska. I mean, I think it's good, a really great thing that she threw out those parts of the case, and they're going to check to validate the signatures. I think that's good. Just in general, I think that's always a good thing with all things, not just because it's cannabis, but just to secure election integrity. Right. And so I think ultimately they'll be fine. I'm pretty sure that they have enough signatures to do this to make those thresholds. And I do like the fact that the judge did rule with some common sense judgment in regards with how they decipher these signatures, because a lot of people have different size handwriting and whatnot. A lot of people go into, like to color outside the lines of their box or whatnot. And, it's a good thing.
No, I understand. I think I appreciate the ruling so far. I think that there is something to be said for making sure that when you're doing things, you're doing them accurately, right? Mm-hmm. I do appreciate there was accountability, even though, yes, we want this measure to pass, for the gentleman who had forged all the signatures on his paid collection efforts. That's shameful. And, I hope that they are able to get this ballot initiative heard and find out what the people of Nebraska actually want. I could understand maybe not wanting to throw your home address down on something. if it's illicit in your state and you're already partaking in it.
Well, especially if you're an elected official, they could be some wackadoodles that are trying to find your address and come like do crazy stuff outside your house.
I mean, the only wackadoodle is a guy who's spearheading this civil litigation. You know, he's alleging that there's these issues with signatures. He's not alleging that they didn't get enough signatures to meet the threshold. He's preemptively suggesting that because there might be some problems with some signatures, that the entire result should be thrown out. And this guy is desperate. It is so sad and pathetic. And this judge is doing a really good job of just calmly batting down the bullshit. But you know it's bullshit when the judge is citing dictionary.com to tell somebody who's a former lawmaker that they are just grasping at straws.
I think they were using that as an example. They weren't citing it in that sense.
She was pointing out that the address without the city and state was satisfactory to satisfy the requirement of having put down an address. But think about the nincompoop who goes through the motions of hiring counsel to complain that the city wasn't put there. Like, motherfucker, get back to doing something productive, because that's not it. And so, this is the byproduct of democracy. It's not what it was actually intended to do. And so this gentleman is super grasping at straws. I don't think he's going to be successful. I think he wants to say that he did everything he could, and he is, and he's throwing everything at the wall. And when she's ruling down whatever, a couple out of 4, it's not sticking. It's not sticking. So at the end of the day, I don't see any of this having a real impact on the ability for voters to have their opinions tallied. The other question I have is, it says that you can't sign up for a ballot initiative if you're not registered to vote. Now, that may be true in that state, but I don't know that that's entirely fair to begin with. If I'm not registered to vote and all of a sudden there's an issue that gets me off my chair because I really want to vote on this issue, I should be able to sign a ballot initiative and then go register to vote before the election, in my opinion.
You know, one other thing, I wonder if through this whole process, if they're going to discover that there were some illegals that signed these petitions as well.
Imagine.
No, Melania does have a visa that's in good standing. We don't need to worry about that.
Yeah, they're definitely not talking about her.